stage, please. Julius Handel. And the panelists for this roundtable discussions are Henrietta Newton-Martin, adjunct lecturer at United Nations, UAE. Haitham Samir Ali, the partner with BLK Partners, UAE. Baijan Brahmbhatt, Director, Legal Compliance and Business Development with Precision Drilling, UAE. Fawaz Mubki, the co-founder and head, Mastery Law Firm, Saudi Arabia. And the last but not the least, Liman Abdul Muttalib Muhammad, Managing Solicitor, Limo at Law, Ghana. Please join us. Now, I hand over the session to our moderator, Julius Handler.
Thank you so much. And thanks to all for your patience for sticking it out until the end. This will prove to be an interesting topic. Given that it's at the end of the day, and to keep this interesting, I suggest that we take audience questions as and when they arise. So please do stand up, shout, raise your hand if you have something that you want to add. So to kick things off, it'll be great to hear a few words from each of our speakers on the panel and hear about them, an introduction to their practice and what they do, starting with Henrietta.
Okay. Good evening, everyone. Well, this is Henrietta Newton-Martin with you. I'm a legal generalist by profession. At present, I serve Harton Advisory. And also, I'm working on a UN-based project that is an academic project. Well, that's about me. Thank you.
Hello, everyone. My name is Fawaz Al-Mubki. I am co-founder and the head of legal consultations at Mastery Law Firm LLB. Also, I'm specialized in commercial cases and labor cases as well. And I am passionate of development also.
Brilliant. Good evening, everyone. Okay, now it's working. My name is Haitham Ali. I'm a partner at BLK Partners Law Firm, which is a regional law firm. We are operating in 4 countries with 5 offices. My practice is over the 3 past decades was litigation. 15 years I've been in the UAE, and I practice mostly all kinds of local litigation in front of the UAE local courts. That's what I do mostly.
Hello, everyone. I'm Liman A. Mohammed, barrister and solicitor of the Supreme Court of Ghana. I am the managing partner of Limo at Law, based in Accra, Ghana. We are specialized in corporate and commercial law, general litigation, and a licensed insolvency practitioner in Ghana. Thank you.
Thanks so much. So, a very diverse panel from different geographies, perspectives, backgrounds, which I think lends itself very well to a topic as broad as this, litigation management, legal ethics. Starting with Henrietta.
Yes.
You have an interesting practice. You're gracing us with your kind of academic insights and your UN involvement. What does the topic mean to you based on your experience, your insights, the topic of litigation management, ethics?
Okay, so first I'd like to talk about litigation management and ethics. So just to set the perspective, we all understand, of course, what are legal standards and what are ethics. Legal standards, of course, they are territorially different from one country to another, and that is normally devised by different countries, that is, and promulgated by legislations, that is the legal standards. And ethical standards, of course, they are based on human edicts. Now, it cannot be denied that legal standards and ethics are correlated. There is a union between two, and we need to understand that as custodians of law, because we are, lawyers, judges, or even legal professionals, they are custodians of law and societal values, and that cannot be denied. So in our practice, and even in my experience as in-house counsel, and having, at present being associated even with a UN project, so I realized that ethics and law are interconnected, and it cannot be denied that, even while we handle any particular case, ethics is involved. For example, in litigation management, when we talk about evidence, for example, most of the countries in the world say perjury is an offense. And talking about UAE, the Penal Code of UAE says, as per Article 253 and 257, that perjury is an offense. Now, moreover, even lawyers, judges, arbitrators for that matter, even translators are not impregnable to do whatever they want. They are, in fact, they are bound by the law, even if you're a lawyer or a judge. For example, Article 257 says, if a judge takes a particular witness, accepts a witness, knowing that the witness has committed perjury, or he himself is involved in something and gives a judgment that based on a false witness, so the judges or even the lawyer knows it, so their practice would be suspended at least for a year or more, depending upon the facts and circumstances of the case. And on the other hand, in case it is proved, then they might even be sentenced to, say, 3 years to 15 years, depending, again, because there's a cross-reference there to the UAE Penal Code under Article 63. So law and ethics, they are as if married together, they are stuck together. Sometimes it may be oblivious that, or we may push it into oblivion rather, that ethics is involved in the practice of law. We might push it into oblivion, but it cannot be denied that it is an integral part of law. So I just spoke about evidence, like I spoke about perjury, the lawyers and judges also being bound by the law, even though they are from the legal field. Now, even forgery, for instance, again, that's an example where ethics is involved, like fake document creation. And, in UAE, in fact, raising a fake claim or filing a false case, in some parts of the world you call it malicious prosecution, but here in UAE, okay, fake claims, even how trivial the matter might seem, so they do take such offenders into task. And the imprisonment can be from 6 months to even 15 years, if at all, depending again on facts and circumstances of the case, if there is a cross-reference to Article 63 of the UAE Penal Code. So that's about forgery. Now, talking about UN, the United Nations Congress in the year 1990, that is, to be precise, on the 7th of September 1990, there was kind of an instrument that they signed, they adopted rather an instrument which spoke about the role of lawyers, where law and ethics again are involved there, and they thumped upon the aspect that lawyers need to maintain confidentiality, governments need to take initiative in terms of, giving rather free access to their people to legal aid, and that organizations have to be set up and so on and so forth. So the UNO also is involved, and they have set up certain guidelines for lawyers. Apart from that, there is this international legal association, bar association at London, where they normally talk about two main aspects about, confidentiality. Again, that's a basic concept which they thump upon that, and it is written in their text saying that, yes, confidentiality has to be maintained by the lawyers in the best interest of the client, and of course, especially if it comes to even public interest litigation, the intricacies of that particular litigation has to be explained to the clients. So this is about it for now. And I'll go on with the next question when you ask me.
Brilliant.
Yeah, thank you.
Fawaz, obviously a very broad topic. And we've heard interesting points from Henrietta on litigation management and ethics. Do you have a particular impression or particular points that you want to get across?
Yes, hello everyone. Actually, I will address this subject from another point of view. Ethics, in my opinion, it's addressed in Saudi. We'll talk about it from Saudi law. There is a professional ethics policy issued by Ministry of Justice. It's mentioned in the first or second article, I can't recall it now, the purpose of this law, of this policy. It says we issue this for lawyer to save the dignity for this career. So the ministry want to issue this policy to make sure that lawyers play, or let's say practice this job and dignity. So they mentioned about 46 article, all of which is doing one thing. Mentioned cases, guides for lawyers, so they know where is the line you don't cross. For example, we have the law prohibited you file a case against your defendants for your clients for 2 years. However, if you discover there is a perjury or something wrong in the power of attorney, this article will be waived. So there is some kind of situations that law give to attorney practice. So there is no vague in this process. Myself, I talk about my personal experience in that. Last year, I have a client for almost 1 year. My client, after that, the relationship end, contract and we didn't renew. So after 3 months, another client of me hired me to sue my client. The fees was very high, so it was challenging for me. I have to find a solution. I couldn't do it because there is a law set boundaries that you cannot do that. So in this case, myself, I excuse the client, and that's it.
Very interesting. Hi, Fam. You've obviously been in practice for a long time. Lots of experience working across different types of fora, dispute, and in different types of law firm, and managing litigation and coming across these issues on a daily basis. Do you have any particular impressions on the topic?
Yes, sure. First of all, I mean, we all apply ethics in our normal lives, in our daily life. So if we compare it to being lawyers, where we are bound by, as my colleagues started to say, by the ethical laws or the secrecy of what you are facing. And of course, definitely at certain times you are approached by one of the clients or a potential client who would want you to try to twist things around in order for him to secure a win. And definitely this is prohibited ethically as a person, and also it is prohibited by the laws that are applied, especially here in the UAE. And as my colleague Fawaz also mentioned, in Saudi, I know there is a law in that regard. And those are the issues that a lawyer is bound by those standards, and why some lawyers can be particularly sued for, like not abiding by the law or trying to, interfere any kind of influence from an unethical side by maybe coming up with a fake document or a fake witness statement or things like that. So definitely we are bound by that kind of ethical behavior. And the ethical behavior starts from the moment you meet your client, where you're also bound by telling him the right situation of his case. And I know people who have a certain dispute or who are, like hit by a certain amount of money, and they want the rights to be, retrieved. They want to hear what they want to hear. They don't want you to give them, as the same when you go to a doctor and you are expecting from him to give you a certain treatment. The same people come to us, they want to hear that, oh, I'm going to win the case for you. And unfortunately, some of the lawyers, of course, they will do that. And but being ethical and being straightforward is the best way, because even if you lose this client because he did not hear what he wanted to hear, believe me, that client is going to come to you later and tell you, I went to someone else, and the situation now is even worse from the moment I came to you, because he tried to do 1, 2, 3, 4, and that fired back on me. Because if you're playing around, the first thing a person is going to be hit is the client before the lawyer, because he's the one who's suffering that dispute, whether he's a plaintiff or a defendant. So we have an obligation, whether it's an ethical or a legal one, to be completely and always using the proper approach, the right approach, the ethical approach, and to be always transparent and clear on everything you're doing. Even though we are bound by secrecy towards our clients, but that doesn't mean we're gonna, go and, inform about the client coming to you and telling you that he committed a crime. Even though by law we're bound not to do that, but we have an option there where to reject that client and reject that case, rather than taking it for, just because I want to make money out of it, and then it falls back in a very bad situation. So when it comes to that, and to the topic we have today, which is the litigation management, part of that is how to manage the file in a proper way, even though you might see that your client's position is not that strong, and you could have done something to make it better, but no, you should always stick to that ethical approach and just put the case where it should be, and inform your client about it, and not to take any bad step, which will definitely fire back on the client and on the lawyer eventually.
It's really interesting, and clearly you can see where clients' commercial objectives and your duties as a lawyer and a regulated professional come into conflict, on which point be very interested in the Ghanaian perspective as both a solicitor and a barrister. Any particular kind of impressions you think you would like to share?
Thank you very much. Thank you. Thank you very much. On litigation management, I think that my understanding of litigation management is simply looking at the planning, the organization, directing and controlling the dispute resolution mechanism from the beginning to the end, in order to achieve the objectives that have been set by you and the client. That is my simple understanding of litigation management. When it comes to ethics, these are rules of professional responsibilities that lawyers are required to observe in their practice. And these rules impose some duties on the public, on the court, on the client, and then on the profession. These four are very important. As a practitioner, there are duties imposed on you to behave in a responsible manner towards the court, towards your client, towards the public, and towards the profession. So you will find out that in whatever profession you find yourself, for instance in Ghana, before you are called to the bar, you are required to be of high moral character and proven integrity. That is the test. So what it means is that as you interact with the courts, as you interact with your clients, as you interact with the public, as you interact with the profession, it's very critical that you ensure that these behaviors cut across. And why is it important? We are in an environment where perceptions affect the delivery of legal services. So if these rules are not there, then there's likely to be that kind of effect on the delivery of legal services. So that is why ethical rules are very, very important. In Ghana, we have the regulator. That is the General Legal Council that has been constituted to ensure that all legal matters, all ethical issues regarding lawyers, are addressed. So there's a mechanism where people can report to the General Legal Counsel. If it's about fees, you've charged above the fee level or the number of hours or conflict of interest, and then they will go through the process and then come out with a ruling. Beside that, we have the Ghana Bar Association, which is a voluntary association that also have ethical rules that as long as you are a member, you must also conform or abide by the rules. Beyond that, we also have regional association that lawyers are part. That is the African Bar Association. They also have their ethical rules that once you are a member, you are supposed to also comply. And I believe at the international level, we have the International Bar Association, which I believe also have rules that as a member, you must also ensure that you conform because of the reasons that I have enumerated. Thank you.
I think a striking point that came out is that legal ethics starts at the very beginning. It starts at the beginning of the relationship. And it would be interesting to hear from the panel as to how you embed strong legal ethics, manage client expectations from the very outset in the engagement letter. When you're onboarding a client, what do you do to ensure that you are satisfied, that you're discharging your duties, and that the matter and the relationship will be conducted to the highest ethical standards? Let's go back to Henrietta to kick this off.
Thank you. Well, I think firstly, I recall a particular treatise by Kitchener and Anderson where he spoke about five-fold cornerstone principle for lawyers. So before I delve into that entirely, I think I would just brush through this aspect as well, where he talks about autonomy, where a lawyer is an independent thinker. He adopts autonomy, and then he talks about justice. Now, interestingly, when he speaks about justice in his treatise, he says that treat equals equally and unequals unequally. Now, this might seem a little bit oxymoronic because when we talk about human rights, ethics, we talk about equality. But when it comes to law and rendering of justice, it cannot be denied that we need to treat equals equally and unequals unequally. As my friend Mr. Hedem, he just pointed out about an aspect where sometimes a lawyer can or rather may or may not take a particular case in case it goes against his ethics. Okay, so referring to that, and even coming back to this aspect of Kitchener and Anderson, where he says treat equals equally and unequals unequally, but when you represent them in the court in the pursuit of justice, a lawyer needs to find the difference why he is defending that particular person and what are the points of difference and why he's being treated unequally when he's prosecuting a case. Why should a person be treated unequally? So this is what Kitchener and Anderson says, that in the pursuit of justice, sometimes you're bound to treat people unequally. This goes against ethics, against the concept of equality, against even if you want to talk about the Universal Declaration of Human Rights, Article 1, it talks about equality, or any other constitution in the world for that matter. In the world, every country has its own constitution, and of course it operates as a grand norm, and that, again, they talk about equality. But as a professional, as a lawyer, even as an in-house counsel, there are certain matters that you will have to handle based upon the principle, treating certain things equally, or certain people equally, and some people unequally. So apart from that, he speaks about how a lawyer needs to defend the client. Even if you are an in-house counsel, the first thing that they would do is you work around the code of ethics of a particular organization. The first thing is you work around the code of ethics. Or let me put it this way. Let me go step by step. The first thing as an in-house counsel to address your question would be, first you refer to the code of ethics, or as an in-house counsel, or even because I've got the experience of both, being in-house counsel and also being part of a law firm. So being part of a law firm, our services was engaged And being part of an in-house counsel, we used to engage the services of a law firm. So playing both the roles. So I would say that the first thing that a company does, being a corporate lawyer, being an in-house counsel, the company does is they would refer to the code of ethics internally. That cannot be denied again, because we really do. And then when a matter comes forth, then we take it forth to the top management and ask their advice on that. Then after that, we hire the services of a particular law firm, having studied the cost factor as well. So the first thing is you work around it, you look to the ethics, then you study the cost factor as well, and you see the best. And then you see their services management level, how they serve, because it's not always about the fees, but it's also about the services they render, how effectively they render, and then it is also about settlement arrangement or settlement agreement, because while you're dealing with cases, and while you raise evidence in-house, and while you raise even witnesses, you marshal through the witness strategy, while you go through that, the other party gets to know, yes, they are getting the case stronger. For example, recovery of dues. Your documents get stronger, your witnesses get stronger, and then there is a possibility that they might come in for a settlement. So in-house counsel will not even forget the aspect of settlement strategy, where you check the inflection points there and the off-ramps and the inflection points, and then you go around it. And in my experience, sometimes you even use risk analysis model like ZOPA, that is the zones of possible agreement, decision trees, and then you arrive at settlement. Now, if at all there is an external counsel involved, we sit across the table and we try to explain to them the exact situation. We coordinate with them, okay? And then we try to resolve the situation. But as an in-house counsel, before all these things happen, the first thing is we nip the matter in the bud. We see that before the problem or the conflict, the first stage is the conflict stage. Before the conflict it evolves into a dispute, we see that we nip the matter in the bud. Why? Because cost factor is involved. Not that we do not want the services of an external counsel. We have plenty of them when we are a company. We have several law firms that are attached to us, apart from having an internal legal team. So we try to nip the matter in the bud because no one wants disputes. It's not just cost factor, it's also about no one wants dispute. The rigmarole of it, we do not want to go through the rigmarole, through the tedious process, and it has its own vicissitudes. We go through that. You hire the services of a lawyer, then it's also, this time factor as well. Now, talking about client management when you onboard a client as an external counsel, what is the agreement and how ethics are involved? I'd like to reiterate what my friend, Mr. Haitham, said. He says that you will have to explain to your client exactly what the situation is. Now, apart from that, just to add to and to respond to the question what Mr. Julius asked us, he spoke about how would you, draw an agreement with the client. Of course, the agreement would be a normal agreement, services agreement, and we would talk about even the risks involved, and a kind of a disclaimer there that whether we win the case or lose the case, we wouldn't say that yes, for 100% you're going to win the case. Sometimes, though it's normal to say that truth always wins, but sometimes truth always doesn't win. So this is where, again, ethics is involved. So while defending, at least I know in some jurisdictions, because I've been a legal practitioner and also I've had an audience before the High Court of Mumbai. So there are sometimes when you defend as a lawyer, I'm sure anyone cannot deny that, I wouldn't say twist and turn, but there are ways how you put forth facts, and there are ways how you elicit witnesses, and how you raise evidence and how you prepare evidence. right? So, of course, yeah, you set the ball rolling at the initial stage by explaining to the client what it is and the strategy that is involved and the risk factor there. And yeah, so that's about it.
Very interesting.
Thank you.
Thank you, Henrietta. Fawaz, again, be interesting. We've heard, not from the in-house perspective, but from your perspective, working in Saudi as a private practitioner, what do you look out for at the beginning of a client relationship? How do you protect yourself in the engagement letter? What are the red flags to ethical concerns, and how do you react to them?
Okay, actually, we usually first contacted by in-house attorney in the companies. So what we do first, we check if there is conflict of interest. After that, we don't over NDA, but upon client request, we don't want to impose a lot of work on us. Second, we go to the next step, which we meet with the client. We listen very carefully because usually the source of information are your client. So we need to describe the case in the light of law. Some clients come with an idea or description for his case, or it's a criminal case. We find out it's not a criminal case, it's just ordinary, it's maybe commercial. So we have this conflict between us that as expert lawyer, I can predict the law, predict the applicable law for this particular case. So this is first, we start from here to describe the situation of the client. Your client is this step, we will do this. We negotiate his weaknesses. Usually we don't do it in the first meeting because we need to run research and find out. Usually we study the history between the client and his defendant. It's very important to find more information. After that, we don't give oral or maybe consultation within the meeting, first meeting. Where usually we set another appointment, usually remotely, and we give the full consultation. We describe each element of what we are going to do. So the scope of work will be clear. Our clients in Saudi Arabia usually expect clients they offer the issue of power of attorney, and they just want reports, don't want to go inside the case. This is companies in Saudi Arabia, most of them prefer this method. So now we have the case set and ready to be filed. We usually sign a contract, service contract, as my colleague says. We mention everything, fees. By Saudi law, we cannot mention percentage winning the case. However, we can say we set a percentage between that and that, for example, from 80 to 99. For example, if it's very clear, for myself, I never do that. I say it's promising case or not a promising case. So this is also another conflict, another point. Some clients, they come to you with their files, they dream about it at night. I'm gonna gain this money from the defendants. And after we review the documents, evidence very carefully, we find out you have very weak cases or very weak evidence, and it cannot stand in front of courts. So usually, especially if the client is important for us, we try to break it down a little bit. So maybe we lose the client. It's happening a lot. If you face your client with the truth, they just fire you and find another lawyer. This is very challenging from a business perspective, exactly. This is one step. Also, we run some, we have an investigation department. They do usually research on the evidence itself. We find sometimes there is a witness. Our client says he witnessed the situation, some situation. We find out this witness wasn't in the country at the time. So this was very challenging because we already filed the case. So we cannot withdraw, according to Saudi law, you cannot withdraw the case after the first hearing session set already. So we drop the client. So sometimes there is a conflict of interest between us as at the end of the day we are practicing business. So we need to make money. Also, the client, we need to give him satisfaction, happiness, so he can give us more work, more businesses. So that's it.
Very interesting. Mindful of the time, and we've discussed legal ethics at some length. Now, Haytham and I, before this panel and in preparation, we're discussing the point about litigation management, managing a dispute in Dubai, in the Dubai courts, how that compares to managing a dispute under common law. And Haytham has really interesting views and experiences regarding this. I was wondering, Haytham, if you might be able to pick up on those issues.
I was speaking to Julius as he mentioned. I have live examples where, I mean, there's a lot of expats living in UAE, and some of them have cases where they are related to each other, whether they are in front of the UAE courts and in front of the UK courts. And we all know that we operate on a completely different systems. So here, as you all know, we work under what we call the civil code, and of course the UK and other countries under the common law. So one example I had is that one of my clients who had a case, who has still a case in the UK, he was hit in the UAE by a precautionary attachment, which blocked all of his bank accounts. As a result of that, he was unable to complete payments to his legal representation in the UK. So the judge in the UK was surprised that how you get hit by precautionary attachment and you didn't know about it from before. So we were asked by the court to prepare a kind of commentary or a small advice on how the process here and precautionary attachment under the UAE laws. The whole idea behind it is for that person not to know about it until it's issued and it's been announced, meaning your bank has received an order from the court to block your accounts. Because if you know, easily you will withdraw your money from the bank and hide it someplace. So we had that difficulty, if you want, to try to explain it to a judge in the UK, how this process works. And here you'll see how sometimes there are a lot of differences, but also there are some similarities. And it's always very interesting and informative, if you want, while we're dealing with the UK lawyers, such as yourself, how we learn from each other. But the whole idea there was, like we were educating our colleagues in the UK about some of our processes, and we were also being educated by them. And we were trying to fill in the gap between those two different systems in a way to explain how our system works here and the system there. Another example I had, which was a big case, a person who had several cases in the UAE decided to go back to the UK and raise the same cases there, being a UK national. And I think you know better than me that he has the right to adjudicate a case there. So also we had a big challenge there also to explain to the court in the UK how all of the steps and the processes that happened in the UAE, and we had to give, as practitioners here in the UAE, like expert opinions, if you want, rather than witness statements, but expert opinions about the system in the UAE and how courts, convene and so on. So, for example, at a certain point, you would be in front of a panel of judges, but for some reason, that judge, he might resign, or at that a moment in time, he might be taken to a different court. So we had to explain also to the UK courts why do judges change and during the course of a case. So there were some challenges, but of course, the whole idea for me as a lawyer, where I was really being educated about a completely different system, which I have very few knowledge about. But of course, with time now we have some more knowledge. But again, the most important part is showing those type of similarities and the differences and how the law from two different angles can really work together and at the same time not work together.
It's really interesting. And touching on that and the idea of translating your knowledge of the legal system from a Ghanaian perspective when you're advising clients who may not be familiar with how a dispute or litigation works in Ghana, what would you say are the kind of key considerations, perhaps the idiosyncrasies and particularities of litigating in Ghana, going through the Ghanaian courts? How do you explain the picture to a client who might be international, doesn't have experience litigating in the Ghanaian courts?
Thank you very much. So I think what is important is the conference with the client. It's always very important to have a conference with the client to understand what the instructions are. Based on the instructions, I will always want to do some kind of legal opinion based on which I can discuss with the client what the legal options are. And as a common law country, it appears to be a bit simple because the judicial system is such a way that basically it's the facts plus the evidence plus the applicable law that is what is used to arrive at the judicial decision. The facts, the evidence, and the applicable law. So once you have a very good conference with the client, then you can also ask for the evidence at that particular point. Based on the facts and the evidence coming from the client, then you as a lawyer, you know which laws to apply. Because it's the facts and the evidence that will point to which applicable law you have to use. So once you get this put together and also understand what the objective of the client is, it becomes very easier to be able to explain to the client. Because the decision you have to take has to do with jurisdiction, applicable law, and then enforcement. These are the critical, questions that you need to be able to answer and to be able to explain. Because when a client walks into your firm, at the end, he wants to be able to enforce the judgment. It's not just about going to court. So once you look at it in that perspective, you are able to explain to the client. And in fact, depending on your understanding of the instructions, you may be able to adopt certain strategies to be able to get the results quicker. Because if the evidence is such that you can plead or you can put your facts in such a way that the other party has no option but to admit, then it becomes easier for you to go for what we call judgment or admission, or to go for summary judgment, or they may not even enter appearance or file defense. Then in that case, you can go for default judgment. So I think that once you understand the instructions and you get the evidence, apply the law, it becomes very easier to be able to explain to the client the options that are available and at each of the stages what is going to happen. Thank you.
Brilliant, thank you. Before we open the floor to questions, it would be great if the members of the panel could very briefly, maybe less than a minute, if possible, provide their concluding thoughts on topics, highlight or underscore anything that's come out of this afternoon's discussion, and perhaps some key practical takeaways. Doesn't need to be all of that, but could be one final concluding remark. Henrietta?
Okay, so I think the final concluding remark from my side would be to practice non-malfeasance as well, along with benevolence, that is in the best interest of your client, in the best interest or the welfare of your client. Apart from that, you'll have to apply ethics. And ethics and law are intertwined and cannot be forgotten. And, you do whatever you do, you work in the best interest of your client. And as in-house counsel, strategize or try to unite legal strategy with business objectives as in-house counsel. So legal strategy with business objective, and not forgetting non-malfeasance, and working in the best interest of your client or your company, not forgetting or pushing, ethics into oblivion in your practice. So this is about it.
Brilliant, thank you.
I'd like to, I'm sorry, just another thing with respect to litigation management. I think taking into consideration that time is a resource. Dubai, in 2018, they've come up with C3 codes. Interestingly, what is C3 codes for those from our friends from other countries? C3 codes are codes where, the court of instance, the appellate court, and the Supreme Court work all together one time. Yeah? So the Supreme Court, the court of first instance, the appellate court, and the Supreme Court work together one time while in the dispensation of justice, or while disposing of a case where the entire case is resolved within 30 days. We call it C3 courts, unlike the other parts of the world where we first go to the court of first instance or the trial court or whatever you may call it in your country. The court of first instance, the appellate court, and the Supreme Court. So we have C3 courts here. And as part of litigation management, again, there are softwares where in-house counsels use, like Case Pacer and so on.
Brilliant. Thank you so much. Fawaz, final thoughts?
Yeah, I think ethics, as we practice ethics daily, can also ethics apply to all lawsuits. So we can start from the beginning, meeting the client, and the final judgment issue and enforcement. So ethics usually can apply in each stage. For example, with enforcement, sometime when we enforce a judgment in our client favor or the opposite, you can apply the judgment directly to the court, or you can contact even the defendants to apply it out the court. So we have options to play by ethics or not. Most of the defendants, after issuing the final judgment, they apply it ambiguously. So we can try this way first before we go to the court for the enforcement.
Brilliant. Thank you. Haytham?
Yeah, I would say choose ethics over money.
That's a great soundbite.
Yeah. And another important point I wanted also to add to this is that document everything you do with your client.
Agreed.
Every meeting you meet with him, even verbally, after you finish the meeting. My older daughter is also a lawyer. She just started her career, and every time I sit with her and tell her, the moment you come out from a meeting with a client, she's working in a different law firm to get her training. Go back to your desk, write an email, send to the client exactly what you discussed, and upon issuing the engagement letter, of course, after you do the conflict check and everything, mention in the letter of engagement to answer you about how we protect yourself, the documents that he gave you. Mm-hmm. Mention it one by one. Mention it by one and mention the instructions properly, because at that moment he won't be able to come back and say you did this and you did that. Document everything. So those are the two main points I would conclude with.
I think those are really excellent, important practical points, carving out the scope of your advice, making sure it's caveated, qualified. I understand the facts to be A, B, and C. Therefore, I am advising on A, B, and C. It protects yourself. It gives the client total transparency over what you're able to opine over. And sometimes the client isn't very clear of the facts themselves or hasn't given you everything. So I think your second point is crucial. I think the first point you made about documenting properly what's been said with clients is particularly important in a world where you might be having WhatsApps with clients, and that presents new issues. Whilst in, 20 years ago, correspondence might have been very formal, with letters, with notes of conferences, with counsel and lawyers. Now it's much more informal. A lot of the advice I give is over email or over telephone. I engage in WhatsApps with clients, and that's fine, but yeah, it does provide challenges. I export WhatsApp chats onto a central filing system so that they just don't disappear. And then there's a really clear record of what you've advised the client, because, as good as it is to have a great relationship with a client, you need to have a record of what you've told them so you can ensure that you keep track of that. And also sometimes the relationship does go sour. The client wants to point to things you've said, will want to go back to what the advice was, and you need to do it to protect yourself and to ensure that you have a record of acting in an ethical way. Now, Liman, final words before we open the floor to the audience.
Okay. For me, I think that effective communication is very important. As you engage the client, there should be a communication plan from the beginning. Sometimes, depending on the nature of transaction, I may have meetings once in a month with my corporate clients, sometimes once in a quarter. And anytime maybe we go to court and come back, at least you send an update to the client so that at least everything is well noted. I think for certain jurisdictions, anti-money laundering check is also very important. In Ghana, it is a requirement because all lawyers are classified as accountable institutions. And there are certain category of clients that when you are dealing with, you must ensure that there's a check, just like a conflict check, so that at least you don't find yourself, to be breaching the law. So I think that is what I have to add.
Brilliant. Thank you so much. Thank you, everyone. Any questions, comments, observations from the audience? Brilliant. In that case, thank you very much. I think I'll hand over to our conference organizer now to let us know what the next steps are.
Thank you so much for this wonderful session. Now I request the moderator to present the mementos to our participants. Okay, yeah, you can go ahead and then. Yeah, just the photo. Photo. One sec, photo. Photo. Photo is pending, I guess. Oh yeah.